Hi, I'm Scott Hervey with Weintraub Tobin.
And I'm Josh Escovedo with Weintraub Tobin. Welcome to another installment of The Briefing by the IP Law Blog. Scott, I understand there's an update on GEO Group's defamation case against Netflix.
Yeah, that's right. Last week, GEO Group dismissed its defamation lawsuit against Netflix. And we covered this previously, but I think it's interesting to give a little recap and then we can talk about the dismissal. So GEO Group, they operate private prisons and detention centers. And the producers of the Netflix program Messiah used the GEO Group logo in the third and fourth episodes of that show, Messiah, where the character is detained at an immigration facility in Texas, which is identified with the GEO Group's logos.
And apparently, the episodes show GEO detaining immigrants in overcrowded, overheated rooms with chain link cages and depriving them of beds, bedding, sunshine, recreation, and educational opportunities. In its complaint, GEO insists that it does not house people in overcrowded rooms with chain link cages at its facilities, but instead it provides beds, bedding, air conditioning, indoor and outdoor recreational spaces, soccer fields, classrooms, libraries, and other amenities.
That's correct. According to the pictures attached to GEO's complaint, when it filed the complaint, GEO alleged that Netflix presents the GEO facility as a particularly shabby, rundown place where people are portrayed as spending their days and nights in cramped, overcrowded rooms and chain link cages. GEO accused Netflix of portraying the facility in a defamatory manner, in an untrue manner. And GEO sued Netflix and the producers of Messiah for trademark infringement. But what we found more interesting was their defamation claim. So on a motion to dismiss, Netflix claimed that GEO blew this all out of proportion. Netflix claimed that GEO's logos on guard uniforms, buses, and the facilities were barely visible, were fleeting, and background material. What was more interesting was Netflix argument relying on the First Amendment protections. Netflix was extremely aggressive in those arguments and basically told the court that the lawsuit should be tossed because GEO's claims are based on 28 seconds of snippets in 2 episodes of the show. And also that Netflix portrayal of GEO and use of GEO's logos was protected by the First Amendment.
In its motion to dismiss, Netflix claims that GEO's case should be dismissed under the Rogers test, which we've talked about frequently on the briefing. Apparently, the judge wasn't necessarily in agreement. The judge repeatedly questioned the artistic relevance in using the GEO mark and said that it wasn't clear to him, which is interesting in and of itself, Scott, since we talk about this very low bar about the requirement to be deemed artistic for purposes of the Rogers test.
Right, but I think that it's interesting. Maybe the judge was conflating the defamation lawsuit and the Rogers test, which looks at the use of a trademark infringement claim, which looks at the use of a third-party trademark in an artistic work. But apparently, after the motion to dismiss was denied, Netflix and GEO engaged in some discovery scuffles. Last week, Netflix opposed the magistrate judge's decision to deny some of Netflix's requests for more information, including discovery regarding the actual conditions of GEO's detention centers. Netflix argued that the substantial truth is a defense to GEO's claims that its image has been ruined. And as we know, truth is an absolute defense to any type of defamation claim. So apparently, after the motion to dismiss was denied, Netflix and GEO engaged in some discovery scuffles. Last week, Netflix opposed a magistrate judge's decision to deny some of Netflix's requests for more information, including discovery aimed at the actual conditions of GEO's detention centers. Obviously, Netflix was arguing that, substantial truth is a defense to GEO's claim of defamation, which is absolutely the case. And Netflix wanted to rebut GEO's claim that they were injured and that Netflix showed their supposedly pristine conditions of their detention facilities, and that GEO's pristine reputation had been damaged by Netflix portrayal of GEO in the television show. Netflix wrote in its brief, quote, "Yet plaintiffs refused to allow Netflix to test the alleged, quote, real life conditions of their facilities as alleged in their complaint." Josh, I feel that Netflix eventually was going to get that, because truth is an absolute defense to a defamation claim, and GEO is going to have to relent on that. So I don't know. I mean, it was very surprising when on May 1st, GEO dismissed its complaint with prejudice.
Is it that surprising though, Scott? Or,
I mean, what is it? The Shakespearean line, "Thou doth protest too much," comes to mind here, right? I mean, you really have to be careful, right? And then this is, I guess, a lesson for those that don't like the way their brand might be portrayed in an artistic work. If they're going to allege that their brand is defamed, like, you better make sure that your brand is pristine, because the defendant has the right to investigate the truth and prove the truth of their allegations, because truth is a defense.
And I suppose the CEO of the GEO Group could have kept quiet as well. I mean, with a lawsuit like this, and it seems like they didn't want anybody poking around in their business. And he was so outspoken about how Netflix had defamed their system and their company. And it looks kind of bad when they then dismiss the claim before Netflix has a chance to come in and check out the real conditions.
I'm not a political attorney, but and I don't play one on television, but like, I think this just really runs bad for GEO Group, right? I mean, you make these allegations that the way that their detention facilities are portrayed in the show are so far away from the truth, and then you sue the broadcaster for defamation, and then when the broadcaster wants to investigate the actual conditions of the detention facility to show truth as a defense, you dismiss the complaint. Like, I don't know, if I were Congressional Oversight Committee or Homeland Security or whoever it is that's paying GEO Group to detain whoever's being detained there, mostly immigrants, I don't know, I would maybe look into this, because it just doesn't smell good. So that's a lesson, right? Lesson number one for lawsuits: don't bring a lawsuit if you don't want to air your dirty laundry in public.
I think that's a valuable lesson, Scott.
Right. So,
thank you.
But let's get on to really what I wanted to talk about here, which was the fact that New York finally passed a post-mortem right of publicity statute. Actually, it was passed last year, and it took 180 days to come into effect. And so it's just now come into effect. New York's previous right of publicity laws, they were actually an extension of New York's statutory right of privacy laws, which provided that any person whose name or likeness is used within New York for advertising or trade purposes without their written consent can sue for an injunction or damages. Now, because the past statute addressed privacy concerns, and those dissipate at death, the rights did not extend post-mortem. And New York courts have held that the state's laws afford no common law right of publicity. So all they had was the statutory grant, and that expired when the celebrity expired.
So New York's law now brings it closer to California, which has had post-mortem protection for the right of publicity of celebrities and personalities since 1985. Under the new New York law, successors in interest of personalities and performers who pass away after the statute takes effect in May of 2021, or 6 days ago, will have a cause of action for certain forms of unauthorized exploitation.
Right. And the statute defines what qualified personalities and qualified performers are. A qualified personality is a New York resident whose name, voice, signature, photograph, or likeness has commercial value at the time of or because of their death. This protection is granted, the protection is against unauthorized use, and it lasts for 40 years from their death. Now, a qualified performer is someone residing in New York at the time of their death that had regularly acted, sang, danced, or played a musical instrument. And the statute has a specific prohibition against unauthorized use of a deceased performer's digital replica. And the statute actually also specifically addresses pornographic deepfakes. Now, these post-mortem rights, the post-mortem rights attached to a performer, they don't expire, unlike a personality.
I understand that similar statutes had been proposed numerous times, but seemed to fail over First Amendment concerns.
That's right. There was concern about balancing out the First Amendment concerns against right of publicity concerns. And the statute created carve-outs for the use of deceased personalities' likeness in a wide variety of, I guess what you would say, creative works, right? Books, plays, magazines, newspapers, etc. Likewise, same thing for the use of a deceased performer's likeness, right? They're allowed to be used in creative works, works of parody, satire, commentary, criticism, and the like. And also in news and public affairs and sports programs, they're not liable for using the likeness of a deceased personality or a deceased celebrity.
I also noted that the statute isn't retroactive, so it does nothing to protect the post-mortem right of publicity of Marilyn Monroe.
Marilyn Monroe, when she died, her estate claimed, even though she was living in California, her estate claimed New York as her legal domicile for tax purposes. Now, at that time, California had recognized post-mortem right of publicity. New York did not. And when the Monroe estate attempted to control the use of her image by third parties, the Ninth Circuit ruled that the Monroe estate did not have a valid right of publicity claim. Now, had this new law been in place at the time of her death, Miss Monroe's estate may have been able to enforce post-mortem right of publicity. Without these rights, though, the estate has relied on and continues to rely on trademark rights to curb misuses of her name and her likeness.
That's interesting, Scott. Well, I suppose at least they weren't without some remedy. Thanks for watching. I hope you enjoyed this installment of the briefing by the IP Law Blog. If you're interested in additional content, please subscribe to our YouTube channel, subscribe to our podcast, or visit our website at theiplawblog.com.
Thanks, Josh.
Thanks, Scott.